Keep Our Republic is a nonpartisan, nonprofit organization. Since the spring of 2020, we've been doing our part to help keep our republic. We do it through hyper-localized civic education. We talk with Americans through town halls, legal seminars, media briefings, and other events. We know a lot of Americans have a lot of questions right now about how our democracy really works. Questions like, what actually happens behind the scenes on election night, and just what is the power of the federal courts? That's why we're talking directly to election officials and judges from across the country. Together, we can help answer some of those questions. Good afternoon, everyone. Welcome back to Keepers of Our Republic. My name is Brooke Bergen. I'm the Special Projects Manager here at Keep Our Republic. If you're new here, we are a nonpartisan, nonprofit organization working to strengthen trust in our elections and our democratic institutions. Today, I have the honor of sitting down with Judge Philip Pro, who served in the federal judiciary for over 35 years. He served as a U.S. magistrate judge before being appointed to the U.S. District Court in the District of Nevada. Since retiring from the bench, Judge Pro has become a sought-after mediator and arbitrator. He's also previously served as an assistant U.S. attorney. He worked at the Nevada Gaming Commission, and over the years, he's held many distinguished positions on committees and advisory boards, and recently has joined Keep Our Republic's Article 3 Coalition, which brings together federal retired judges from across the country advocating on behalf of an independent judiciary and, of course, the rule of law in our country. We are so honored to have Judge Pro here with me here today. Thanks for joining us and welcome.
Thank you, Brooke. I'm delighted to speak with you and delighted to be part of the A3C, as we call ourselves, the Article 3 Coalition.
Let's talk a little bit about A3C for a second. What motivated you to join? What interested you in joining this coalition when I know you've already got a ton of other things on your plate, even as you are technically retired these days?
Well, I was a prime candidate probably to join the coalition. I had paid attention to the Chief Justice's year-end report at the end of December, and he had quite a good discussion about the last several years, the increase in threats to members of the federal judiciary, violence, including, unfortunately, some deaths of federal judges and family members of federal judges. And I was aware of these, but he really brought home how it's been increasing and the rhetoric that we've been witnessing in the last couple of decades almost has just gotten more and more intense and corrosive, with aspersions cast at the individual judges that sit on the federal judiciary and render decisions. They're doing their jobs, that's all they're doing, but it can provoke some really intense reactions from people. And after the change in the administration in February, I was obviously aware, as most people were, certainly most judges were, of a number of executive orders being issued that provoked lawsuits in the courts, which turned out to involve a lot of temporary restraining orders, injunctive relief, staying those executive orders temporarily so that the cases could be heard. And when those were issued, the kinds of reactions that I witnessed coming from high government officials, people that are elected to the highest public offices in the country, making the kinds of public statements that I saw attacking my colleagues, even though I'm retired, they're my colleagues on the federal judiciary, I found frankly outrageous and unfair, particularly unfair because they cannot respond to those kinds of attacks. They're precluded by the canons of ethics that apply to judges that prevent them, other than what they say in open court or in their written opinions, from responding when they get attacked. Now, judges get attacked all the time, attacked in the sense that criticized. That's fine. Just being criticized because you issue a decision that's inappropriate is fair game. I mean, we're public officials too. But these were of a different nature, and these were personal attacks and attacks on the judge and their families. And so I think I was a prime candidate. I spoke out about it at a local bar luncheon here in Nevada and encouraged the members of the bar at that luncheon to get involved in their mini communities and speak out also on behalf of the federal judiciary. And a couple of weeks later, I received a call. This was in mid-April, early mid-April, from one of the one of my colleagues involved with the Article 3 Judges Coalition and inviting me to join. Well, he didn't have to say much more than, our commitment, our pledge is to defend the rule of law and federal judges and to protect the independence of he had me to defend the rule of law. I mean, of course, to have the opportunity to join with, it was a very small cadre at that time, it was less than 10, but now I think it's
Grown
over
significantly
50.
since, yeah.
Yeah, grown tremendously. And it'll grow even further, I anticipate in the near future. But to join arms and forces with so many of my wonderful retired colleagues who care just as passionately about the rule of law, about the judicial branch and the importance of it, the foundational importance of it to it's a cornerstone of our Constitution. It really is. And to defend that, to defend our colleagues who are doing the hard work, and it is hard work, of rendering these decisions fully and fairly, and trying to do so without external pressures or without threats. It was a no-brainer, frankly, for me. I had to,
Yeah.
I'd have been ashamed of myself if I hadn't signed up right away.
Well, and in a way, it makes a ton of sense knowing a little bit about your background. You spent the vast majority of your career in various positions of public service. You started as a public defender. You were an AUSA, both in Vegas and in Reno, I think, right?
Right.
And before moving on to the magistrate bench. And what drew you to a career in public service? A notoriously not well-paying area of law to go into when you had so much that was available for you when you stepped out of law school.
One of my colleagues characterized being called to the bench as taking vows of dignified poverty. And that's probably a good
That's good.
description of it. Indeed, you don't spend your career in public service to enrich yourself. At least you shouldn't. Uh,
Right.
and it's just I think a calling that starts when why do you become a lawyer? In fact,
Mhm.
that was my experience. I never met a lawyer till I went to law school. I didn't even know one. I didn't come from a background with lawyers in the family or neighbors who were lawyers. Pretty humble background. But I was an argumentative kid around the dinner table, and my family was, all right, stop, Phil. You ought to be a lawyer, and I think it sunk in when I was a child. But over the years, when I was in high school, we had a new president, John F. Kennedy, and
Mhm.
he inspired a lot of us. This was back
Yeah.
when he was elected in the 60s, so 61, 62, 63. Uh, ask not what your country can do for you, ask what you can do for your country. That sounds kind of trite and it's historical, but it really had a message, and other things were going on at that time.
Sure.
Books, movies coming. To Kill a Mockingbird, a good example that started to communicate with young people, and there were many of us, the civil rights movement that was going on as we're growing up in the 50s. Uh, so many things about growing up, and maybe where I grew up in the San Francisco Bay Area, uh, kind of interested me in doing something that was worthwhile in my mind and help other people. And the law seemed like the ideal vehicle to do that. So
Mm.
I migrated towards in that direction. And I think after law school, I went to Las Vegas to spend 1 year as a judicial law clerk. It's been a long year. It's been over 53 years now, uh, most of my life. And basically my entire professional career. But clerking for the judge that I clerked for really drove home to me how meaningful that kind of
Yeah.
work could be. And I had the opportunity to develop my trial skills as a deputy public defender, defending indigent criminal defendants, as a federal prosecutor in the U.S. Attorney's Office. And I even went into, for a little over a year, into private law practice with a couple of partners in Reno. And it was fun setting up the business. But after a while, I look at myself in the mirror and say, what are you doing? Is this why you went to law school? And for me, it
Mhm.
wasn't. For me, I wanted to do something else. And so I channeled back in. And Nevada was growing very quickly. The legal community was growing very quickly. And the opportunities were considerable, much greater than they were in the San Francisco Bay Area. I knew I wasn't going back. I met my wife and, of course, put down roots, started a family. So that just led. And then I was so fortunate to become a magistrate judge at a time when that was just taking off as a judgeship within the federal judiciary. It was really being
Yeah.
developed. We had a
What
terrible
year
fire. It
did you
was
join? Sorry to interrupt,
1980.
but it's so fascinating. Okay, so this would have been not long after was it the Federal Magistrates Act sort of changed the
In
whole
60,
structure.
68,
Okay,
68, and it evolved in 72 further.
right.
And that most of the magistrate judges in the country were still commissioners. And
Mhm.
that changed in warp speed. And I caught it
Yeah.
like a rocket. Uh,
Yeah.
the MGM hotel burned, a grand fire case, and I worked on that for 3 years. And so I developed some uh, acumen and skills dealing with complex civil litigation in
Yeah.
that. And it primed me then. That was in 1980. And 6 years later, I was told I was going to be nominated and was confirmed the following year, 1987, on the article as an Article 3 judge. And that's where I spent my career.
So going back, we do have some listeners who eh, aren't members of the legal profession. For those who are listening, explain just really briefly, like what is a magistrate? It might not be something that everyone is familiar with if you haven't gone through a major litigation process.
Now, it's not a judgeship that was created by the Constitution. Article 3 judges, which district judges, Court of Appeals judges, and Supreme Court justices are appointed in accord with the provisions under Article 3 of the Constitution. And when we're appointed by the president, confirmed by the U.S. Senate, the president signs our commission, and we're appointed for life. We hold office basically until we die. We can retire from active service as I have done, as I did in a decade ago in 2015. Uh, but you basically continue in office, and you can't be removed or kicked out except by impeachment. Same provision for impeachment for other high federal officials. Um, the magistrate judge system is one that evolved from the what used to be called the commissioner system, founded in 1789, or after the Judiciary Act, legislatively. And it was to have, you couldn't have a federal judge, an Article 3 judge in every community in the United States, even in the colonies, the few states that we had at that time. So they would commission through the judiciary uh, a local judge or some other person to serve as a judicial officer, a quasi judgeship, if you will. And that was the commissioner system that existed until 1968. Um, they would sign search warrants, they would conduct initial criminal appearances when a person's first brought before a judge and advised of the charges, given their due process rights. The judiciary, the federal judiciary, realized we're not able to get new Article 3 judges as fast as this country is growing.
Right.
And we have to go through Congress as part of a big omnibus judgeship bill, and they're difficult to get. And so they decided to carve out their own adjunct, if you will. So magistrate judges and bankruptcy judges, which are under another act of Congress, are appointed for fixed terms by the judges of the court. They're not bankruptcy judges, magistrate judges are not Article 3 judges. They're appointed by the judiciary to fill a specific niche or area for the judiciary. But the magistrate judges system became so useful that different duties became assigned. And the act that was passed by Congress, 636, provided for the reference of matters to magistrate judges, provided for under statute, or as may be necessary or found necessary by the court, found appropriate by the courts. Well, that opened the door. And so they have a full range of duties now. It's a wonderful judgeship, and they'll provide wonderful services to the country and the judiciary writ large.
And I know you mentioned briefly a few minutes ago, the MGM Grand matter. Obviously, for those of you who aren't familiar, that was a massive multi-district piece of litigation that occurred after a very tragic fire in your home city of Las Vegas that claimed dozens of lives. You can obviously know better than
I
I,
think it
but
was 85 or 86 people
oh God.
perished, and thousands of other people were injured. And yeah,
Yeah.
it was a disaster of magnitude, just hard to comprehend, I think.
Yeah.
So
And
that
led to
was
this huge litigation, the pretrial litigation that you oversaw. I can't even, just from a logistics standpoint, how how did you even go about trying to organize what was such a massive undertaking that was happening across, I mean, there were depositions happening across the world, I think, for that litigation.
there were, yeah. Well,
Yeah.
it was a wonderful experience as a professional, not because of the tragic
Sure,
loss of
not as a
itself,
human, but yeah.
but to try and get your arms around it. And I was blessed to have a judge named Louis Bechtel from Philadelphia, who was an experienced multi-district judge who was assigned to handle the case. And I was the magistrate judge that he asked. I was the only magistrate judge in Las Vegas at the time. And I told him I'd like to work with him as he would use his magistrate judges in Philly. And I said, I've been thinking that with all of the discovery coming in, discovery of issues, I ought to conduct regular discovery hearings, maybe every 3 weeks or every month. And he said, that's a great idea, Phil. Do them every week. Well, he was right. He knew exactly what he was structuring. And I did. And I would set every Wednesday morning at 7 a.m. an agenda of motions to compel different discovery disputes on an agenda. We basically dispensed with the normal procedures under the federal rules of civil procedure and local rules and set up this system whereby if you, on behalf of your client, filed a motion to compel on Thursday, it would automatically go on the agenda the following Wednesday at 7 a.m. And the other side could come in or they could respond ahead of time. And we'd talk about it. We'd basically work our way through the discovery issues. And I did 135 of those during the course of the litigation before it settled. Things kind of started to fall into place because the system got set up. They understood what the protocols were going to be, what the expectations were going to be. With Judge Bechtel's approval, we appointed a special master who later became Supreme Court Justice here in Nevada, Michael Cherry, to manage and oversee, I think it was 14 tracks of depositions all over the world of deponents. And it was a real effort, but quite an experience, and it worked very well. And we did manage to get it settled. This was before computers. We didn't have any of the way of, we rented an office and had files of all of the discovery requests and so forth, in addition to the clerk's office. But this was for things that weren't coming into the clerk's office that people could go to and get caught up if they were brought into the case recently and things like
Yeah.
that. We
And
talk for
it's
hours about that. You don't want to hear hours of
I
discussion of the
I
issue.
would listen to it gladly for hours, but I will not subject everyone else listening to us right now to that. You're welcome, listeners. But it's interesting because I think it kind of highlights that what a lot of people don't realize, which is that judges, whether you're magistrates, but particularly Article 3 judges, or even state court judges, have enormous flexibility and should have enormous flexibility with how they deal with their calendar, putting aside some procedure, standard procedural rules in order to accommodate, what is directly in front of them and to deal with, and it's so much more agile than perhaps our other branches of government because you have to be, right?
Well, you raise something that's really important, and it's an example of why the independence of the judiciary. We've got our three branches
Hmm.
of government, uh, and they're they're separate, but they're co-equal and codependent.
Right.
We've each got our own. It's like a three-legged stool,
Yep.
is the way I always describe it. You know, it's a very stable foundation. And the cornerstone of it, particularly within the judicial branch, really for the entire country, is the rule of law. Uh, Very simple idea that everybody is equal under the law. Nobody is so powerful as the law doesn't apply to them.
Hmm.
And to protect that, you've got to have an independent judiciary. A hallmark of an independent judiciary is the ability to manage its own docket, its own
Yeah.
cases, to set up the structures. That includes establishing the magistrate judges system. It includes the discovery rules that we have. Now, Congress plays a part in all of that. The legislative branch does. Uh, Even rules changes have to be to the federal rules have to be
Right.
approved by Congress, but they basically are automatically at the end of every year when there's changes to the rules. They pass legislation and enacted into law when signed by the president and the executive branch, the second branch, that approves procedures that the judiciary can use. And we're able to then hire the people that work in our court, manage our dockets, and in a way that allows us to do the very difficult job of adjudicating cases fully and fairly according to the rule of law without external inappropriate pressures.
Right. So let's talk about Maryland because as we're recording, that's sort of like the legal elephant in the room of things that are happening right now. Um, for those who are unfamiliar, the Department of Justice recently filed a lawsuit against the entire Maryland federal bench after the Chief Justice of the Maryland bench imposed a standing order essentially establishing I think it's 2 business day pause on deportations for immigrants who were filing habeas petitions in federal court. DOJ filing a lawsuit against the entire Maryland federal bench for what many people would say is just doing their job, being flexible and agile to accommodate this unprecedented surge in immigration proceedings before it, is itself completely unprecedented. And Judge, I know you've spoken a little bit publicly for Keep Our Republic or in the Article 3 coalition about this issue. And I was just wondering if you could talk to us about it now, about your thoughts on what's going on here.
Sure, right now it's under advisement. I don't think that
Yeah.
the judge who was assigned from out of the District of Maryland has rendered his decision on the motion by the judges to dismiss the lawsuit by the Department of Justice, but I'm sure that'll be forthcoming probably by the time anybody sees this. I expect it will.
I
Uh,
would hope.
so I'm not, and when I spoke about it on NPR radio, I wouldn't comment directly on the merits of the case
Sure.
because I didn't want to be one of those people out sitting in the wings trying to influence a judge who has responsibility to decide it. But I'll just say that as you describe, we have to be able to manage our dockets, and we do this all the time. And what the case involved was simply the District of Maryland being flooded by habeas petitions to be brought before the court to establish their identity. Some may have been
Mhm.
claiming that's not me, the person they want to remove. These were a cadre of individuals who were allegedly, and perhaps were in nearly all cases, in the United States illegally from another country, and they were pending, quote, removal. In other words, they could be deported from the United States. But the uh, Immigration Service decided, or Homeland Security decided, these people are subject to removal. We're gonna take them out, and they were sending them to El Salvador, I think it was, and a few other places. And they were doing it on weekends, Friday night,
Mhm.
Saturday morning flights, things of that sort. Well, these people would file a petition or try to file a petition, but even if they filed one, the person they'd be spirited out of the country before it could even be looked at by the court. All that the judges did, a very sensible thing, and the type of thing we do all the time when
Right.
the pandemic hit, other events that occur, we have to make accommodations. All we're doing is saying, give us 48 hours. They entered a standing order saying will need 48 business days, 48 hours in a business day, 2 business days,
Yeah.
basically, to be able to receive the habeas petition, look at it, determine our own jurisdiction, reference it to the Department of Justice, and get the petitioner before the court to determine the merits of this petition. And to that, the Department of Justice elected to do something that I had never seen. And if it's not unprecedented, it's certainly very rare, and file a lawsuit against all 15 Article 3 district judges. Um, Totally unnecessary. There were other vehicles to raise the same legal issues they want
Right.
with one case before one judge. But this emasculated the ability of the District of Maryland to conduct any of these cases until this case is resolved. I mean, it was just unnecessary. And that's not an attack on the judiciary directly that is trying to provoke some kind of violent public outrage, but it is an attack on the independence of the judiciary and the separation of
Mhm.
powers. In my view, it's the executive branch, Article 2, stepping in to Article 3, those powers which are the province of the judiciary under Article 3. And that makes that stool wobbly. When you
Yeah.
start to weaken one uh, branch of the government, one leg of that three-legged stool, and allow another branch to usurp that to some degree, you're weakening the foundation that allows us to preserve the rule of law in this country.
Yeah.
And that's wrong. It's not legal.
Yeah. What really disturbed me personally about that situation is it's appears to me to be, at least in the court of public opinion, which as usual these days is how a lot of this is playing out, exploiting like an education, like a civic education gap we have, and some of the rhetoric about the DOJ's um, uh, a stance or argument in this situation is, oh well, the court has taken this extraordinary, unheard of step of requiring this 48-hour stay, and those of us that are more familiar or have received more substantial legal civic training are like, that doesn't seem very, that's just a court managing its docket. And but when people don't realize how potentially ordinary, if not boring, a court managing its docket is, and that's a pretty normal step for an Article 3 court to be taking, if people don't know that that's just kind of how our courts work, it can be easy for people to exploit that knowledge gap and say, look at this extraordinary thing we're doing. And it's that's what's scary, so scary. I mean, on top of different levels of scary of what's happening to me is how easy it is to exploit people's lack of understanding of how our judicial systems really work in this country. Yeah.
Well, it's part of the mission of the Article 3 judges coalition, civic education, and you nailed it. Civic education is critical in a democracy, in our democratic republic. When Benjamin Franklin talked to Mrs. Powell, I believe was her name, and she asked about what kind of government we have. A republic, if you can keep it. Well, it's not, as a noted historian, I think Michael Kamen wrote once, it's not a perpetual motion machine that will go of itself. It requires the energy of an informed and committed, involved, engaged citizenry. And we have to have that. And it seems that there's a dearth of civic education in our schools now. And I know it's picking up. I've been involved in civic education projects since I was in law school, since 1969, of different kinds. And a major one here in the District of Nevada called We the People, which is all over the country. And it's a marvelous program started by the Center for Civic Education. There are countless other programs, and they reach a lot of students, elementary, middle school, high school students. But really, unless you are a lawyer and a practicing lawyer, nobody's going to walk around with the kind of knowledge you have as a lawyer, or I have as a retired judge, about all of those nuances. And that's not the point. That's not what's necessary. Right. What's necessary is that we have a fundamental understanding on the part of the electorate, on the part of the citizenry, that there are three branches of government, that the legislative is the first branch, and what their functions are. They have enumerated powers conferred in the Constitution, given to them by the people. The president, the head of the executive branch in Article 2, the same thing. Their power isn't unlimited. The power is still vested in the people. It's granted to the chief executive officer, the president, to do certain things, and they're laid out in Article 2. The same with the judiciary. And the judiciary is different because we're not elected to our seats. It's a political process, the appointment process, but we're not elected. We're not put in office to do as the legislators are, or the president and his administration or her administration to have their platform and try and advance that they were elected to do. We're elected to be the guardrail, if you will, to make sure that what they do is constitutional. They pass laws. We have to do the same thing. We have to follow them. We have to follow the Constitution. Our caseload is limited to cases arising under the Constitution and laws of the United States. And so we don't have jurisdiction to jump into a bunch of different things, most of which are handled in state court or by other mechanisms. But when we have jurisdiction, we really have it. And we have a responsibility. When something happens, like the cases in Maryland, for example, that comes into federal court under the habeas corpus statutes, but it could be something else that occurs. I don't see something in the paper saying, oh my gosh, that looks like it violates the Constitution. I'm going to go start a case on that. It doesn't happen. We're totally reactive. I can't do a doggone thing about it.
You can't go out and find yourself a case, right?
Like, I don't
not how it
solicit
works.
cases. And believe me, we have enough of them. So
we don't need more.
Yourself or somebody who's a lawyer or a person pro se files a lawsuit, initiates a case, it's brought into court, and then the first thing we do is look at it and see, do we have jurisdiction here? Is this a case or controversy that I, as the judge, have jurisdiction to proceed with? And then you do according to the rules, according to the structure that's set up for the judiciary. And we're obviously required, incumbent upon us, is to provide due process to the parties. You don't just say because somebody announces we're going to do this. I know it's different, but we're going to do this because I got elected and this is what I want to do. It doesn't work that way. If it's challenged, the other side gets a voice. They have an opportunity to respond to whatever the action is. The parties that are in conflict, all a court is a forum to resolve disputes. society throughout history has always had a mechanism to resolve disputes. Ours is a little more refined in a developed country like the United States, but it's still just a place where people that have legal issues, conflicts, issues that are very humid, very passionate about, come before the court to try and get resolved. And our job is to create an environment in which they can do so peacefully, uh, having the due process rights that every litigant is entitled to in our courts, and according to the law that applies and the facts that inform the case, not based upon popular opinion, not based upon what a newspaper writes, not based upon what people are marching in the streets about. Those are things that are important, and the legislature and the executive certainly are heeding and paying attention to that and trying to explain their positions. But we have to do it according to the evidence that's admissible in the case and according to the law that applies. And that's our job. And the judges that have been issuing rulings that have been subjected to this kind of harassment from high-level executive positions are doing just that. They're doing their job. It's fine to disagree with them. It's fine to criticize them. You could say, I don't like that. The administration or the attorney general doesn't like that decision, and we're appealing. Well,
Right.
bless you. That's exactly what you should do. Let the process play out. Let it go through the court system as provided in the Constitution.
Mhm.
You're going to win some, you're going to lose some. That's the way dispute resolution in court or anyplace else proceeds. That's what happens. And there are usually corrective mechanisms for a mistake. If I, as a district judge, make a mistake, don't understand the law, miss some important point, well, there's three judges sitting on the Court of Appeals that are going to correct my papers, and they'll set it right. Or there's nine in Washington, D.C. that are going to set it right. And at the end of the day, well, I say the wheels of justice grind slowly, but they grind very fine. They get it right. And if it's still not what the people want, there's a mechanism for correcting that. There's legislative opportunities to change the law. There are constitutional opportunities, as we've done 27 times, to amend the Constitution. So you want to stay in your lanes within these three branches. And when you start to push out of that, it creates a whole list of problems. And then to compound it by this corrosive, absolutely unnecessary ad hominem attacks on judges, it does nothing legitimate for the discussion that's being had on the issues, the legal issues, because it's not going to affect the outcome. But it's also corrosive in terms of the public understanding and public confidence and public trust in the institutions of government, including the courts. We have limits on what we can do to enforce our orders. We issue a ruling, and we can impose sanctions on attorneys or parties that violate those. We have contempt power to take action to correct. We can go administratively to bar associations, send a letter that a lawyer has conducted themselves inappropriately and so forth for disciplinary action. But at the end of the day, the whole system, our whole government, and this is the judiciary certainly, but it also applies as between the other branches and one another. We depend upon the public's trust and confidence in the government, in the republic. If that's lost, well, Franklin's warning needs to be heeded by people. That can be very risky to the stability of our republic. And I'm not suggesting that we're in that territory. We've had for 235, 36 years since the Judiciary Act, or the Constitution is actually written and then later ratified, we've had constant tension. There's always going to be tension between the
Hmm.
branches and issues. And my goodness, we had an unfortunate second constitutional convention. We call it a civil war to,
Yeah.
to deal with some of them. The founders wrote an incredible framework for a government. Was it perfect? Of course not. It failed to address the original sin of slavery, for example. It failed to ensure the right to vote to all citizens, including women, including others that were in this country that were later determined to be entitled to vote. Uh, these were egregious failures, but as the founders said in the preamble to the Constitution, they had ordained a more perfect union, not a perfect union. And these are human beings. All of us are. None of us are going to make perfect judicial rulings or
No.
perfect policy decisions or perfect legislative votes. We're human beings, and we've got some failures in our history that we could all point to at different times that illustrate that very well. But really, on the whole, if you stop and think about it, take a look at the long view for over 200, almost 250 years, uh, God, we've done a good job, and we'll continue to do that. I'm confident that as difficult as the current episodes are, that we'll get through this. It'll sort out, but you've got to give the process an opportunity to work. And when you start making attacks on judges for rulings they've made, that gives license to people in society who maybe not only aren't aware of their civic responsibilities as a citizen, but maybe are quick to look at it as a call for action. And when they take
Hmm.
that kind of action, that's where you have these pizzas sent to. I can talk about that. You probably know all about that. I don't know whether you want me to, but what a horrible example of judges and family members of judges being sent pizzas that they didn't order. These are messages to them that we know where you live. We know where your family lives. Some of those pizzas were sent in the name of the son, Daniel,
Yeah.
of Judge Esther Salas, who was murdered when he answered the door to someone posing as a delivery man. He was really a
Just
lawyer
a
who was just
horribly
thrown.
sad situation.
It's
Yeah.
just incredible. And we've had other examples, but pizza sent in Daniel's name. I mean, that's unforgivable. That,
Yeah.
there's and social media. When a high government official speaks from the bully pulpit of you know, the Capitol or the White House or the Department of Justice, uh, and it's picked up on social media. It spreads like wildfire, and there's no excuse for that. It may sound like hardball politics, but it's there's no legitimate reason to do it, and it does real harm to
Right.
the institution of government.
Well, and as we wind down here, I just briefly want to touch on at the end what you mentioned is sort of the frustrating irony is that these attacks or these ad hominem attacks and this litigating in the public forum as opposed to keeping it where it usually belongs in a motion or a filing or in a court argument um, is even more difficult in the face of the fact that your currently sitting colleagues who are currently on the bench it's improper. They don't have an opportunity to kind of speak up on their own behalf when these things like these attacks, these ad hominem attacks, and sometimes these physical attacks are occurring. So as someone who was no longer constrained by being a sitting judge, what do you want to say to your colleagues about the moment that we're in? And maybe more specifically, what do you want to say to the public about the importance of having this independent Article 3 branch of government as a bulwark, as the third leg of the stool, like we've talked about?
Well, I think to my colleagues, I think to the to the woman and the men that are part of the Article 3 Judges Coalition. We've all sat where they sit. We've all experienced to differing degrees, maybe not of the same corrosive nature, the kinds of issues that they're confronting, and to assure them that, we've got your back to the extent we can do anything about it and speak out and defend you. But, more importantly, that we can do more than that. We've got to continue to try to inform the public and encourage others to do so. I wrote an article recently in our local bar association monthly news magazine on this very subject, and really along the lines we've been discussing. And, I pointed out, now I'm writing this for lawyers. Well, I'm preaching to the choir. Every lawyer
Sure.
in the state of Nevada and every lawyer in the United States knows what the rule of law is and understands the three branches of government and so forth. But what I encouraged them to do was to reach out or speak up in their communities, in their mini communities, their church communities, their educational communities, their social communities, their professional organization communities, and to bring this issue to the front and remind people that we have a responsibility as citizens of this country to be, in a civic sense, civically virtuous, to be engaged, to be aware, to inform ourselves, we're going to disagree with people all the time. That's fine, but you find ways to compromise. That used to happen in Congress, and still could and still does on occasions, but it's a constant struggle. You can't just sit back and forget about it. Maybe be on guard that you have to be realistic. In this world, the advent of social media, something that never existed for more than half of my life, has kind of occupied the field and allowed for the spread of so much misinformation so quickly. Young people are more and more apathetic, I think, about voting, about understanding what's going on around them politically or legally, and their roles in the government as citizens. That we just keep pushing that, and to get out as much as we can as a coalition, what we're trying to do what we're doing now. And I realize I'm talking to you from Keep Our Republic, but to do the same thing on the Maryland case you gave an example of. Right after that happened, one or two of I know Andre Davis was on NPR radio, and a wonderful colleague, and really so articulate on these matters. And he'd been a district judge in Maryland before he went on the Court of Appeals. And he spoke up on this issue before I even did later when the lawsuit was coming to fruition. That kind of thing. Get out and let as many people know. Use whatever voice we have. At least we can speak with some credibility, not in a partisan political way, because really, while we're constantly monikered as being appointed by President so-and-so versus President so-and-so, that is so distracting. And so, dare I say, and I know scholars might argue about this at the Supreme Court level or maybe even the Court of Appeal, but I served with judges appointed from Harry Truman on down. And I can honestly tell you that with very rare exceptions, I wouldn't have been able to tell you if we ever talked about a case what their political affiliations had been. We're talking about the law. And sure, we're human. We have views, we have opinions. But when the law is clear, when the law says this has got to be the result of these set of facts, that's what you do. You discipline yourself to do that because you taken an oath to do so. So I think
that's the job.
and we need to
That's the whole
coordinate with,
foundation. Yeah.
yeah, and we need to cooperate. The bar, the bar's been under attack. By the bar, I mean the lawyers, the legal
Yeah.
communities, the large law firms, and others. And many of us have signed amicus petitions supporting actions they've taken to stave off some retaliatory actions taken against major law firms and individual lawyers. And we will continue to do that because we rely upon good lawyers who are not coming into court to make a political argument about one thing or another. They're representing a client who's entitled to have the lawyer standing with them advocate their case and put their best case forward and challenge or cross-examine the other side's case.
Mm-hmm.
And when everybody's working on all cylinders, it's like an automobile, it's all working on all cylinders. It works really well.
Right.
And the results you get are good and fair and according to the law. And we can't allow that to be disrupted by the whim of the moment. The part of that Constitution was designed to not create chaos by just, I don't want to say mob rule, but a rule of the majority that disregards the rights and the interests of the minority. It provides a tempering process, a balance to ensure that just because 8 out of 10 want to do this, you can just go sit in a hole while we do it or something. And they've got a right to be heard. They may lose the issue, and that's fine. But they have the opportunity to challenge it. They've got a right to vote. They've got to exercise it. Too many don't. But, we can't stop. We've got to continue, and we've got to defend the separation of powers. We've got to defend the independence of the judiciary to do its job. And we've got, because all of those, any damage to any of those damages the rule of law, the ability to give that ruling that's based solely on the facts and the law that applies in the case, whether you're the richest man in the world or somebody in high political office or a vagrant off the street who's entitled to the same kinds of determinations.
Yeah. Well, I can't think of a better note to end it on. Thank you, Judge Pro, so much for your time, for all that you do for the A3C Coalition, for your work on behalf of all of the topics that we've talked about today. It's been a joy. I'm sure we will get an opportunity to talk again soon, but thanks so much for joining us today.
Pleasure talking to you, and thank you for doing this with the members of A3C. And you'll find, I think, everyone you talk to is similarly committed and passionate about what we're doing and why we think it's important. I mean, it has to be done, and we're old, but we're not going to stop.
Completely agree, and we wouldn't want you to. All right, thanks so much for joining us, and everyone listening, we'll see you next week. Thanks.
Thanks, Brooke.
If you like this episode, please share it on social media and tell your friends. It's the best way for folks to find out about us. I hope you'll agree that our guest is indeed a keeper of the Republic. If you want to learn more about how you can help keep our Republic, stop on over to our website, keepourrepublic.org.